Welcome to the first of a number of interesting law school webinars lined up for this academic year. We are glad you are able to join us for this exciting session entitled the Legal Migration Act 2023, an unlawful affront to justice. Just by way of introduction to this session, anyone following recent global events will be aware of challenges associated with migration generally. Conflicts in Ukraine, Syria, Afghanistan, and the Middle East have raised perennial issues around migration. In the United States of America, as we speak now, there are raging debates about what they refer to as illegal immigration through the southern border of the country. In Europe, there are ongoing debates on how to address challenges associated with migration. Now, coming home to the UK, if you have been following UK politics, you will know that immigration often ignites passions both for and against. Today, I have with me Dr. Paul Arnell, Associate Professor in the Law School, RGU, and an expert in transnational criminal justice, extradition, and human rights to discuss the recently passed Illegal Migration Act 2023. What is this act about, and what is it meant to achieve? Dr. Arnell will help us answer some of these questions today. And as I said, the session is entitled the Illegal Migration Act 2023, an unlawful affront to justice. Dr. Arnell, you are welcome.
Thank you very much, Joseph, for that introduction, and hello, everybody. I'm delighted to be here and to speak to you for half an hour or so, and have a conversation with my colleague in the law school, Dr. Mante, on a subject that I'm quite interested in, and I've been writing about in recent years, aspects of immigration and deportation.
Indeed, I think recently, before this law became a law, when it was a bill, Paul wrote a piece of an article on it, and it was published in a referee journal. So Paul knows what he's going to discuss here. And those of you who are followers of this webinar will know that normally Dr. Arnell is the one who sits in as the host. Today, I am the host of your webinar. My name is Dr. Joseph Mante. So, let's get into it right away. Paul, so what is this subject all about? Can you give us some background to this whole subject?
Yes, of course. Thank you, Joseph. I guess I can answer that question in any number of ways, but I think in simple terms, it's about migration and the movement of peoples, and at the same time, or I guess movement about certain type of peoples, and at the same time about asylum, about the rules that do apply, the international rules in particular, but now how they relate to the national rules that apply to asylum, and generally speaking, the rules that govern whether an individual could be permitted to remain within a country they enter. So, and simply, it's about, I think, the movement of people and the law relating to refugees, and I suppose in the current context, I mean, this is by no means a new subject. There's been, I suppose, ever since the start of human history, the movement of peoples across borders, and for various reasons, environmental, political, military, famine, persecution, all sorts of reasons. simply the opportunity or the desire to improve one's lot and have a better life. So there's been this movement of peoples for a variety of reasons over the centuries, and continues, as we know, by looking in the news almost every day. There'll be a story about it in one way or other, about people crossing borders. And particularly from a UK context, there's been a history of this following the First and Second World Wars, and in particular in relation to the movement of peoples between Ireland and the UK, and then in more recent decades between some Commonwealth countries in the UK for a variety of reasons. But I think just like in the modern context, what we want to speak about later this evening, the turning point, I think, of the modern point in which things had changed was the Second World War, as with so many things, and a treaty concluded not long after that, the 1951 Refugee Convention, which I'll say a lot about, and that spawned such a huge displacement of peoples that came to be what turns out to be a pretty broad international consensus that something should be done to protect people, displaced people who have been displaced or fleeing for reasons of persecution. So there was a treaty discussed and finally agreed in 1951 on that score, and that has been applying, I guess, not over 70. Entered in 1954, so 1953 or 54, for almost 70 years, and in one way or other. And now it's again in the UK context, particularly in the news, because of recent events and the movement of peoples, and recent, I think, changes in political viewpoint towards refugees and asylum seekers. And so that's why now, and I guess, and recent, two in particular legislative enactments, the last being passed, as you say, in July this year, the Illegal Migration Act 2023. So that's a bit long-winded introduction. I'm giving some broad scope of this issue.
Yes, but nevertheless, a very comprehensive background to this conversation, setting the scene. In your answer, you referred to the Refugee Convention as one of the main international instruments regulating migration in this area. And I would want you to tell us a bit more about the convention. I know formally it is referred to as Convention Relating to the Status of Refugees, 1991. We often refer to it as the Refugee Convention. What is that convention about, and what does it regulate?
Yeah, well, I think it was and is still the critically, the central piece of international law governing the issue, and it's not a niche treaty by any means. I think there's 146 state parties to the convention, so I think there's roughly 200 countries in the world. So what's my math? That's my math. So is that 75%? I think
about 2/3, yes, of the world. Yes,
that's 75, 150 out of 200. But roughly 3/4 of the planet have become party to it. And the UK was one of the founding parties and sponsors of it. As the UK's approach to these international issues seems to be very different 70 years ago. Similarly, I can make a similar point about human rights and the European Convention on Human Rights, which the UK government in recent years is hostile to that, as it is seemingly now increasingly hostile to the 1951 UN Convention relating to the status of refugees. Originally, this set out a set of rules to apply to events up to 1951 occurring in continental Europe, or generally applying there. There was a possibility of it being extended originally, but there was a protocol, a follow-on agreement in 1967, which expanded it and applies those rules on a truly global basis and without temporal restriction, so without, you know, a finite period in which its application comes to an end. So there's this treaty, and it does a number of important things, and I'm just going to mention a couple of them. One of them is it defines what a refugee is in international law, and I think most countries or state party to or parties to the treaty have adopted this definition, and I'll come to that in a minute. And it also a central feature which is relevant for the Illegal Migration Act in the present case in front of the UK Supreme Court, introduces this principle of non-refoulement, whereby countries cannot return a person to a country where they have fled fearing persecution, simply. So that's, you know, that would be of course contrary to the terms of the treaty, and, you know, just the wrong thing to do. Obviously, somebody's fleeing a country for reasons of persecution and travels to another country, that third country sends them back. That's in breach of a term of the convention. Just getting on to, I mentioned the definition. You have to read it to you so I can, some accurate part of it anyways. The definition of a refugee found in Article 1A2 of the 1951 Convention, and this is really quite important, I think, in common, I just want general discourse about this issue, because it's an important, just a very important point, and often persons critical of migration would suggest that individuals, say, crossing the English Channel are not refugees, but instead are economic migrants or something else, you know, and that is in fact a crucial distinction, because as I'll say, if I'm getting ahead of myself here, if one is not illegally a refugee, then they don't fall under the terms of the convention, and you know, are not covered by its protection. So that's a crucial distinction, and that definition is a refugee is a term that applies to any person who, owing to a well-founded fear of being persecuted for reasons of race, religion, nationality, membership of a particular social group, or political opinion, is outside his country of nationality, and is unable, or owing to such fear unwilling, to avail himself of the protection of that country. So you need to be out of your country and hold a well-founded fear of being persecuted for one of those reasons: race, religion, nationality, membership of a particular social group, or political opinion. And so one falling in that, under that definition, is a refugee and merits a protection under the terms of the treaty, and one who does not fall under that does not merit protection under the treaty. I guess there could be a general, more point to be made. It's not to say those who don't classify as refugees under the treaty, or not covered as refugees under the treaty, don't merit protection. In many cases, they could, or just they should. They're fleeing, you know, if their countries are destitute and there's no, you know, employment prospects, or, you know, starvation or famine or something, that, you know, then should though individuals from those countries be offered some degree of assistance, or indeed led into a country? I would arguably say yes, I think they should, but that wouldn't be as a refugee. Okay, so that, I mean, I'm getting ahead of myself here. So there is this treaty. It sets out the general rules. This principle of non-refoulement is a central one, as is the definition of a refugee.
Thank you very much, Paul. And clearly, this 1951 convention has at its core some level of human rights protection for these individuals who are fleeing from persecution, as you discussed just now. We will get into the distinction between an economic migrant and refugee later on. But as I listen to you, 1951 Refugee Convention, the protocol was 1967. So these laws have been around for a long time. And so why has this subject been in the news in recent years at all? since we've known about this all along?
That's a good question. I mean, there's been in, I guess, historically, movements of peoples, or a displacement of peoples for a variety of reasons, generally conflict, not just in the recent 5 years or so, but for, you know, I can think of the Iraq War, you know, there's wars in Afghanistan in the 1980s.
The Syria War, yes.
Syrian War, I mean, conflicts in Africa, over the years in the Middle East. But you're right to say in the UK context, it's in the last 4 or 5 years, it's been really sort of a touchstone, a controversial issue that's in the news quite commonly and spoken about by politicians. I think there's a couple of reasons. One is the really considerable increase in people crossing the English Channel in small boats, and I haven't mentioned already, but I'm sure that people listening have, you know, remember Rishi Sunak's, one of his pledges when he became Prime Minister was to stop the boats, and this Illegal Migration Act 2023 is part of that. And those numbers have really gone up considerably. I had some stats on that from the Migration Observatory, which is based at the University of Oxford, and it said in 2022 around 46,000 people were recorded as crossing the channel. So, you know, that's quite a large number. In one respect, a large number. I mean, in other senses, perhaps not, but that's another an argument to make. So that has happened, and that had gone up really over the years, in the last 4 or 5 years, really considerably, according to that report in the Migration Observatory. For example, in 2018 there was only 300, and then, you know, 2020 8,500, and then, you know, as I just said, in 2022 46,000. So a really almost an exponential increase.
Exponential increase, yes.
Yeah. So that's one, and, you know, and that makes it's obviously the news, and it's tragic. People are drowning and dying in the English Channel, and there's questions of you know, the RLNI going to you know, rescue them or not, or the Coast Guard interdicting boats, or, you know, or blame being cast in France's direction for what can be seen to permitting it to happen in the first place. And so there's been that, and that's a fact, and that's, I think, one reason why it's entered the public consciousness in recent years, and related to that has been this legislative or the political response, which takes, I think, both the forms of legislation, and there's two main statutes that are relevant, I think, in recent years: the Nationality and Borders Act 2022, and what we're talking about tonight, the Illegal Migration Act 2023. But also there's been, I think, unhelpful political rhetoric by the present Conservative government, and I think this is getting to part of my reason for coming to the title of the talk being, you know, an affront to justice, and that's, I guess, apart from the legality or illegality question, is just that the approach taken, to my mind, is unjust or inhumane, and mirrored by some of these comments. Priti Patel, the former Home Secretary, you know, introduced a new immigration plan, and she said the new plan for immigration when she was Home Secretary, and she said she wanted a system that works for the law-abiding majority against those who abuse our hospitality and generosity, suggesting that people crossing the channel are coming across to to take advantage, in some sense, of the United Kingdom, abuse our hospitality and generosity, were her words. The present Home Secretary, as I said in a speech relatively recently, she said there's a hurricane of mass migration coming to the UK, and spoke in really quite inflammatory terms and about the issue, and just related, not about refugees per se, but related to it. She said, according to the Guardian newspaper, that the Human Rights Act in 1998, which was relevant in this current case pending in front of the Supreme Court, should be named the Criminal Rights Act. I mean, that, to my mind, and I'm I teach human rights here in our law school, and you know, in a supporter of it, and that sort of language is totally unhelpful. And so I just say there's I think that's why, and now that we'll get to the third point. So one, I think there's just been this factual increase in people crossing the English Channel. There's been a legislative and political response, and then there's another, which is the UK's departure from the EU.
I was coming to that, Paul. I was wondering whether the fact that this is back in the consciousness of UK residents has something or anything at all to do with the situation relating to Brexit. And speaking in terms of UK's membership or UK's disengagement from the EU now, does that have any impact on this conversation at all?
Yes, I think it does. It certainly does. I mean, I think the picture is maybe not as black and as white as one might think, but all members of the EU were part of a Dublin II regulation, which was a common approach to asylum within the EU, and it concerned a number of things. For family unification, for example, which was an important aspect of it, but also the rule that an asylum case should be heard at the first country in which an individual enters the European Union. So that under that rule, the UK was generally permitted to remove individuals back to, for example, Greece or Italy or Spain, where they first entered, because the southern European countries are obviously in most cases where a lot of people would enter the EU from the Middle East or Africa, and hence considerable problems in those countries for sure, and overcrowding and other issues, also interdiction of boats and other tragic drownings in the Mediterranean and so forth. But and I'm not still belittling that, a very serious problem. But as a result of leaving the EU, the UK is no longer party to that Dublin II agreement, and the EU has no, or countries in the EU have no legal obligation to accept from the UK anybody who traveled through it to arrive here, and so that certainly has affected the position of the UK to some extent. As I've said, you know, it's not as perhaps as considerable of an effect than one might think, because of these other rules where, for example, under family reunification, that may have been an effect in the opposite direction. But I think there's no question that in under that regulation for sure, but even in a more general cooperative sense, you know, where this is a European issue, certainly, well, it's a global issue. I think it's maybe one of our conclusions. It's certainly, and it's certainly not a UK issue alone. In many countries in Europe have populations of refugees and asylum seekers considerably larger, many times larger in some instances than the UK. But the approach moving forward would have to be, or should be, a cooperative one. But I think that it's fair to say that Brexit has an impact for sure.
Thank you very much, Paul. And since Brexit, I guess, as you explained, the responsibility on the UK government to do something about immigration seemed to be at the forefront of UK politics, and so a number of attempts or efforts have been made over the period since Brexit to tackle this immigration problem. And I think this week the Supreme Court has been considering the so-called Rwandan plan. What is that about? I guess that preceded the Legal Migration Act that we are discussing. So it will be good to understand what the Rwandan plan was all about.
Yes, thank you. I mean, that was just in the news, and the hearing just ended today, I think.
Yeah.
Never read about it today, but it was scheduled to end today, so I assume it did. I guess one thing that I forgot to say in my last point, I mean, it is sort of tragically ironic that, you know, the Brexit, and I'm not getting on my hobby horse about Brexit, even though I was opposed to it. I'll have to hold my hand up about that. But the tragically ironic that the notion behind it, as it was sold, would be the UK would be more able to control its borders, to control immigration. And it's up to this point proving not to be the case, to proving, you know, the opposite is seeming to be true. Of course, you know, people who would accept that, or maybe one could come back and say, yes, it's because of European human rights rules that are stopping the UK, or indeed more generally these international rules, this 1951 treaty, and if we scrapped our membership of the ECHR and the Refugee Convention, then we would truly have control of our own borders. And I didn't even know if that would be true. I mean, you know, one could say that might be true, but ripping up all the important, long-standing international agreements that you've been party to and indeed help write is no way forward, in my view. Okay, sorry now, but as part of the UK's attempt, you're right to say, preceding the Illegal Migration Act 2023, and following the Nationality and Borders Act 2022, 2022, Nationality and Borders Act 2022, the UK entered into an agreement, a memorandum of an understanding with Rwanda, whereby Rwanda promised to take individuals who landed on UK shores and to consider their asylum claims there, with the UK doing, in an asylum sense, nothing at all, other than, you know, I guess sometime process them and putting them on a plane for their asylum claims to be considered by Rwanda. And Rwanda did that, I think, for a number of reasons I've been reading. One of them, I think, was reputational, just to, you know, have a partnership with the UK and strengthen the relationship between the UK and Rwanda. Another one, I think it's fair to say, must be financial. I think the original payment was 140 million pounds from the UK to Rwanda as part of that agreement. So far, that hasn't happened. There was at one stage a plane on the tarmac with some individuals on it, which at the end of the day, there was an interim order by the European Court of Human Rights which prevented that flight from taking off. Subsequently, there was a litigation in the courts in England, the High Court, and then the Court of Appeal. And the Court of Appeal held that the plan could lead to a non-refoulement, so sending on to the country which these individuals originally fled, and with that, a violation of Article 3 of the Convention, that protection against torture and inhuman and degrading treatment or punishment. So that's what two out of the three Court of Appeal judges held at. And then the government was allowed to appeal to the Supreme Court, and that was the case being heard today. So as it stands, there was this plan that was concluded in April 2022 to summarily send individuals from the UK to Rwanda. Nothing's happened yet. The hearing, I think, is ended today, as I say, and I assume there'll be a relatively expedited judgment being issued, maybe within a month or two. I don't know. Of course, I have no idea what will happen, whether the government will be successful at the Supreme Court. If that's the case, I think there could well be a case taken to the European Court of Human Rights. If the government loses in the Supreme Court, so the Court of Appeal decision is upheld, then I don't know. Then it depends on the terms of that judgment. But the UK could seek another party. Maybe there's another country out there that is willing to enter into a similar deal that the courts would judge has that country doesn't entail a risk of a violation of Article 3 and non-refoulement. or the UK could work with Rwanda to get further insurances or to help train up their system and have the Rwanda's asylum system more robust, and so to prevent that risk from happening. I think it's going to be controversial. I think it has been controversial so far. The UK government itself feels very frustrated by this, and certain people, Home Secretary and others, would and get hugely frustrated. What they see is by the interference by or the European Court of Human Rights, firstly, or human rights in a general sense. Now that was applied by UK courts and the Court of Appeal, and indeed by the terms of the Refugee Convention. I mean, Swilla Braverman was saying recently that perhaps things have changed so much since 1951. The terms of the convention, and indeed how it's been interpreted. I think one of the things she mentioned that women and gay people shouldn't be, a woman's sex and a person's homosexuality shouldn't be a ground for upholding a claim for asylum, where in some cases that's I think that would be incredibly wrong. I mean, and reading through my information for today's webinar again to remind myself of one of the largest countries upon which asylum status is granted, or probably would be granted if it got to a hearing, are individuals from Afghanistan under the rule of the Taliban, who have taken an objectively draconian approach to females, and not allowing education or traveling freely from their homes, or banning them from work, and various other things, getting increasingly worse, I think, over the last few years, to my understanding. And so not allowing an Afghani woman to successfully claim asylum in the UK, I think would be unjust.
Thank you very much. And before we get into the Illegal Migration Act, which is sort of the next effort by the government to get into this, get a handle on these migration issues, I just wanted your take as an expert on what the Rwandan plan is likely to cause individuals who are asylum seekers. What will be the consequence? Are they not going to be treated well? What is wrong or right about the Rwandan plan? I'm talking about the consequence on individuals who be involved in this program.
Well, I think it's wrong in a couple of senses. I imagine a vast majority of those who would be considered suitable candidates to be subjected to the plan may never have set foot on Africa in their lives, and they're being sent to the middle of the continent, thousands and thousands of miles away from their home, to a foreign country, to be, and separated from. And often, I think refugees that are coming here have some sort of familial connection or other connection with the United Kingdom already before they came, and to just have this this sort of dramatic. I guess if they've already had through a trauma, and I assume if they have a well-founded fear of persecution, someone who meets the definition of a refugee has undergone, a trauma already, and to be summarily removed without being considered by a UK court or considered at all, I think is wrong in my view. And then, of course, what the Court of Appeal judgment was about was, the possibility of a risk of ill treatment, in Rwanda. Rwanda, to be fair, on the other side of the coin, the MOU. In the MOU, memorandum of understanding, Rwanda's promise to adhere to international law,
yes,
in terms of the Refugee Convention, I think certain international human rights law standards. So in law, I mean, Rwanda has promised to do that. I think, you know, and part of the Court of Appeal decision, my understanding, was looking at the evidence and trying to decide, you know, and has made an assurance of what would happen. Is, you know, can they be legitimately relied on? And that's a tricky question. And in some cases, the courts have deferred to the government. They did that in the situation of Shamima Begum, in a different context though. But you know, the executive has the knowledge and authority to make a call on an issue like that. The courts in this case appear not to. Well, I know up to this point have not done that, and I've held there's a real substantial grounds for believing there's a real risk of a possibility of violation of Article 3 in Rwanda. So the consequences could be dire. I mean, it's a future thing. I can't say for sure. I don't know. It may be fine, but ultimately it's a. I say the some areas or sending somebody against their will to a country thousands and thousands of miles away on a continent from which they may never have been before.
Thank you very much, Paul. And back to the title of this session, that the Illegal Migration Act 2023, an affront to justice. I know that this act was passed in July this year. So perhaps before you share your opinion on the details of the act, what does the act set out to do at all? If you can give us a brief summary of that.
Well, I think it's yeah. I've been so long-winded. We don't have too much time to get on our gist of our subject. But it's an attempt by the UK government through Parliament to address the issue of small boats and not applying only to small boats, but anyone arriving in the UK not part of one of the few established schemes. One from Afghanistan, one from Syria, and there's another one I can't remember just top of my head. But there's several relatively niche schemes, and niche in the sense that not many people have taken advantage of them so far. It's an attempt by the government to address that by deeming everybody who arrives in the United Kingdom outside an established scheme to be subject to summary removal, and any asylum claims to be inadmissible, and places a duty on the Home Secretary to remove everyone in that category, with a small number of exceptions, such as unaccompanied minors, and then there's a duty to remove them once that person turns 18, and those I think at a serious risk of harm, and so that's even further than what would occur normally under refugee law. So it's this attempt just to really stop asylum, basically, just turn the whole system on its head and take a hugely draconian and negative approach to the subject.
Yes, very, very, very poignant point there. Very, very serious. So again, looking at the act and its content, how has it been received so far? From the brief summary you gave us, it appears that it's sort of looking for a workaround the 1951 Refugee Convention and the protocol. And that will mean, as you put it, turning on its head the whole system of asylum, the asylum process. So how has the act been received so far?
Okay, yeah, well, thank you, Joseph. I kind of skipped over something I want to get back to a little bit, but this is more about the illegality and evidence, to my mind, of the illegality is that there's really unprecedented sections in the Illegal Migration Act that, firstly, in the course of its being made, there's a rule in UK law under the Human Rights Act that every new law has to be scrutinized for its compatibility with human rights.
Yes.
And the vast majority are deemed compatible, and the minister in charge of the bill at second reading says, yes, this bill is compatible with human rights. This is one of, I think, only two other examples where the UK government felt it was unable to do it. So when making this bill, and there was an obligation to make a statement of compatibility with human rights, the minister said, I'm sorry, I can't. So that in itself is an illustration that the government thinks
there's something wrong there.
Something wrong. And another, to my mind, an unprecedented feature is that there's a section in the Illegal Migration Act which disapplies another section of the Human Rights Act, which provides that all law be interpreted compatibly with human rights as far as possible. I don't get too complicated here, but this is the Illegal Migration Act disapplies another feature of human rights, this Section 3 interpretive obligation. So there's a couple of sections or features of the Act which really, I think, illustrate and even illustrate the government's even acceptance of the nature of the Act as likely being incompatible with human rights. So that was just, I mentioned that. So I move on. I'm just going to say a bit about the reception because we're almost out of time, and then we have one more question, two more questions. It's I suppose it's who you ask and what you read. I generally read, is it the law or academic commentary, or as well as the reports from the UN Refugee Agency or Joint Council on immigration, and other reports of NGOs, and they're unanimously scathing about the Act. And just I got a quote here too, here from the Joint Council for the Welfare of Immigrants in its 2023 briefing paper, said that the bill, I guess before it was enacted, is an extraordinarily dangerous piece of legislation which flies in the face of international human rights law and will have a devastating impact on people seeking safety in the UK. It represents an effective ban on asylum, and it completely undermines the principle of refugee protection in the United Kingdom. And the UN Refugee Agency similarly said this legislation would amount to an asylum ban, extinguishing the right to seek refugee protection in the UK for those who arrive irregularly. And so these are not, just single academics or somehow people outside the mainstream. These are, experts in the area and qualified people giving their view on the issue.
And Paul, before we get into the next question, can I announce to our guests that if you have a question, I know we're going to have a brief time for to address your questions, but if you have a question, can you pop it into the chat, and then we will pick it up there in a few minutes, and see if we can give you some thoughts on your question. And that takes me to perhaps one of the key questions I've been yearning to ask you. Paul, why do you call the Act an unlawful affront to justice?
Well, I think I made my view pretty clear about that already, but I think that there's two aspects of that. One is the legality, and one I think is just either the morality or the humanity of it. And I think the Act is both. Well, I think it's most likely unlawful, but it's certainly inhumane and unlawful. It flies in the face. It undermines the very essence of the Refugee Convention, which is that somebody lands on the shores of another country, and that country is promised to consider whether they're a refugee or not, and if they are, to grant them asylum. The UK has now said it will not do that for people landing on UK shores that don't come through one of the schemes, which I mentioned. I think there's three of them I just saw, relating to Syria, Afghanistan, and the Ukraine. I think are the three schemes that exist at present, which I think have applied in a limited fashion by virtue of their operation. And so it flies in the face of the Refugee Convention, and it arguably breaches human rights as well, as the Court of Appeal held. If say the Rwandan scheme goes ahead, and there is a chance of refoulement or say inhuman or degrading treatment in Rwanda. So I think there's a question about I think a serious question about the legality, but also the humanity. I think equally important, and I've mentioned this a couple of times. I think by the UK just choosing to do this, basically to opt out of its international obligations and to treat individuals, almost as subhuman or non-human, in some of this language, and it dehumanizes people, and then that is just I say it's an affront to justice, affront to humanity, and from my reading, up to say 2/3 or 3/4 of the people that come across in small boats meet the definition of a refugee. So they have, and this is not an easy test to meet, a well-founded fear of persecution on one of these grounds. And these are, the UN refugee agencies and others have so far as possible analyzed the demographics of these people arriving, coming from Eritrea, Syria, Afghanistan, Sudan, and Iran. I think is the five biggest countries, and most of them, up to 3/4 of them, would be eligible for refugee status. And so the UK is just saying, well, that doesn't matter. You've arrived in a small boat. We're not considering it, and we're summarily deporting you to, or deporting is not the word, summarily removing people to another country. And I think that's just this inhumane. I'm not saying, and this may be our last point if we have time, I'm not saying, of course, the UK is open its borders to everyone. Of course, the UK has to control its borders. You can't be, the recipient for everyone who would like to come. That's just not possible or tenable, and that would entail, perhaps, would certainly entail too great a cost for those individuals already here. But this scheme and this act are not the answer in my view.
Thank you very much, Paul. We have a question in the Q&A chat, but before I go to that, and you will be glad to know that question relates to the one I just asked you, but perhaps asking you to be more specific in terms of what solution there is otherwise than the political solution that we see now. So let perhaps my final question before I invite you to answer that specific Q&A question is, if the plans that we've discussed are obviously not adequate or don't meet human rights standards either domestically or internationally, then what do you suggest be done, Paul?
That's a very good question and a reasonable question, and I don't think it was Suella Braverman, but Priti Patel also said publicly, when she was facing criticism from people like me or human rights lawyers or judges or courts and others, NGOs would say that give me a better solution, exasperated. Because at every turn, to her mind, there was another human rights lawyer or NGO, criticizing the plan, but not coming up with what she thought was a better solution. So I think that's a fair point. And my answer is there's not an easy answer. It's not an easy solution. But dehumanizing people is not the way forward. I think there would have to be a collaborative approach. I mean, I think with our European partners, with other countries. Ultimately, and I say this is a very long-term approach, and it may never happen, sadly, but attempt to address the reasons why people are fleeing their countries. I mean, and that's, you may say this guy is just a very academic with his head in his clouds. If we only could sort out the problems in Syria and Afghanistan, it'd all be fine. Yeah. Well, that's certainly the case. That would certainly help. I think those are the two of the largest countries. But of course, attempts have been made at that in one way or other for 50 years, or indeed more, in some sense, in Afghanistan, I don't know, maybe that long, 50 years or something. But but working towards that with partners, with the UN,
Yes.
attempt to do our best to address the reasons. And instead of what seems to happen with UK and US and other foreign policy in recent years was ill-considered, and indeed has caused the problem in Libya, in Syria, or it certainly contributed to it, and maybe it's caused it is too strong. So I don't know, but I think and other way, I think, what was it, 26? Did I say 26,000 people? Is that what it was? In last year,
46,000.
46. Pardon me. So it's not a small number by any means, but the UK has like 80 million people in it or something. And the scale of the problem in other countries is considerably bigger. And also, it just is maybe a random point from left field, but the UK's population is aging, and we need workers. We need people here, and and the people that come here are pretty hardy. Obviously, they made it all the way over here, and or at least during the determination of their possible asylum, we should let them work. Okay.
I'm afraid I'm going to have to stop you there because I want to get one more question in before we finish the session. Alan is asking, perhaps it's an extension of the earlier question I asked. You've sort of given us an extra judicial or international approach to resolving the problem through cooperation. And Alan is perhaps more specific, asking, given that the arguably illegal state of that legislation we've just discussed, how can the position be remedied other than politically? I don't know if Alan has in mind some legal action as one of the possible ways of looking at this. What do you think, Paul? Briefly.
Yeah, a very good question. I don't know. Of course, the UK Parliament is sovereign. It could pass any legislation it wants. Ideally, I guess there could be an adverse judgment by the European Court of Human Rights. There's no enforcement mechanism under the Refugee Convention. So if the UK wanted to proceed, even in the face of an adverse European Court of Human Rights judgment, it could. So I don't think. And the UK government appears to be really quite committed to this sort of action. So really, I don't know. I don't think there could be ultimately. There's challenges now. If of the Rwandan plan, let alone under the Illegal Migration Act 2023, which I assume there will be. I shouldn't have mentioned a very important point. The most critical aspects of that act are not yet in force, right? I think so it's on the statute books, it's law, but this duty to remove illegal or irregular people is not in force yet. I think the decision, that's probably pending on the Supreme Court litigation and other things. I don't know. I guess I'm maybe going to be rightly criticized for this. I've been, what could happen? I don't know. There certainly will be challenges, but I suppose ultimately the government might be successful in carrying out its policy. That would come at a great cost, and if it is, and I mean, there's been talk about leaving the Refugee Convention or seeking to get it amended, which is probably very difficult, or indeed the European Convention on Human Rights, which would be a catastrophe in my view. But the answers are not easy, I'm afraid. Yeah. But for me, I just draw the line. If it's dehumanizing people, which is a bad thing.
Okay, I'm assuming those will also be your final words on this session. Unless you have anything you want to add before we round up in a minute or so, your final words, Paul.
Well, I had a lot to say, and I don't know if I've got it all out, but I hope I'll give you my.
I think you've done a very, very good job on the topic. We've addressed a number of salient points, so well done on that, Paul.
Okay, I'm done then. Thank you, Joseph.
Thank you very much to our guest. We want to say thank you for your patience and for joining us for this obviously interesting discussion I've had with Dr. Paul Arnell. associate professor in the law school, Robert Gordon University, and an expert in transnational criminal justice, extradition, and human rights. You will agree with me that Paul has done justice to this question, or the series of questions I have asked him. This is a difficult subject, and I did not come in here, or I don't think you came in here thinking that we'll be able to solve all the questions. But I believe what we've managed to do is to raise some interesting issues and food for thought. And so on that note, thank you for joining us, and hopefully we see you on the next live session from the Law School webinar series. Thank you very much.
Thank you. Bye-bye.
Bye.